And so I will be doing that prior to issuing my official ruling. However, I am going to be very candid. I disagree with your position on whether or not there was an ongoing emergency. If someone's calling 911 while someone, unwanted subject, that they're in a domestic violence situation, which we know adds an element there, is in their home, and she's yelling, I don't care if it's expletives or not, and she's yelling that she wants this person out of her home, and then allegedly this person has a weapon.
This hearing started as a technical argument over evidence, but it quickly turned into a courtroom battle over credibility, excuses, and common sense. The defense was trying to block key statements from a domestic violence case because the alleged victim refused to show up. But the second the judge started digging into the timeline, the paperwork issues, and the actual 911 call, the entire tone changed. One side kept trying to narrow the situation into just an argument. The other side kept bringing it back to a screaming 911 call, an unwanted man inside a home, and allegations involving a gun. And once the judge started openly challenging the defense's logic, you could feel this hearing slipping out of their control fast.
State of Michigan versus Jalen Davis, 26-00030. Here, please.
Thank you, Your Honor. May I please report Assistant Prosecutor Attorney Dan Smith here on behalf of the people?
Assistant Public Defender Jessica Straub on behalf of Mr. Jalen Davis, who is sitting to my right.
Mr. Davis is charged with a domestic violence. My understanding is that the people were expecting to run this trial without a victim, correct?
Yes, Your Honor. So there's, I think, yes, that's our understanding.
How we proceed?
At this time, Your Honor, today was scheduled for I think a jury trial. Today was scheduled for
Motion hearing?
a motion hearing. And we emailed the court a couple days ago to determine how the court wanted to proceed. I'm still new in front of the court. I, at this time, don't fully understand how the court would like to the evidence put before it on this type of hearing. So it's my understanding. I spoke with Attorney Straub about just discussing preliminary matters, figuring out what evidence we need to put before the court in order for you to make a determination on what evidence is admissible and what how we're going to be proceeding to trial. So
well, let me just start. Part of the issue is when the motion is filed, did you all file a judge's copy?
yes.
I don't have a judge's copy. It's part of the problem. And definitely don't have a judge's copy for the response that was filed yesterday.
My response was filed
It's
on
date
Friday.
stamped for yesterday.
It was filed on Friday, Your Honor.
It was filed on Friday electronically.
Yes,
At what time?
4:59.
It was filed yesterday. 4:59? We close at 5. You filed something that electronically at 4:59 on Friday. You filed it on Monday.
Your Honor, I was going based on this court's guidance that I had 2 weeks to respond. I took all 2 weeks.
I get that, but if that's not what I'm asking you. It was filed yesterday then, because the court can't receive it until after you file it. If you
Okay.
don't send it until 4:59 and the court's closed, how is it received?
So for future reference, Your Honor, but at what time should I be?
I'm not suggesting that. If I told you you got 2 weeks, you had 2 weeks. I'm just telling you that we didn't receive it until yesterday.
Okay.
Because it was filed Friday evening, which means it cannot be considered received Friday evening.
Would like the record to reflect it was before end of business though.
At 4:59.
Yes, ma'am.
I don't know, because it's like I don't know what time. If you sent it at 4:59, I don't know what time cyberspace sent it to us.
Okay. Fair.
Because sometimes you are sitting right here and send an email and I don't get it for a couple
Very
minutes. So it was, I don't think if you sent it at 4:59, it was before the close of business. I don't think that counts. That's like me running up to the federal court with a motion as they're closing the door to say I filed it. You think the judge is gonna see it that day?
No, but I do think the court would accept it.
I'm not saying I didn't reject it.
Okay.
What I'm saying is I didn't receive a judge's copy.
Okay.
Did you file a judge's copy?
I don't know what that means.
Yeah, when you file a motion, which we don't actually have electronic filing for criminal here, so I don't know how you file anything criminally, electronically. Our filing is in person. To the clerk's office, and they would have the date stamp it, and then it goes into the file, and then you would accompany one that says judge's copy. That doesn't go in the file, that goes to the judge, so that the judge can have a copy to read.
Understood.
If you just file one with the court, they put it in the file. Ask me when I see a file
Understood.
today. That's how I saw you file the response, because I just flipped in here to CEO was stamped for 8 o'clock in the morning yesterday. Of which no one brought it to my attention. So nonetheless, I'm still gonna handle it today. You just gotta give me an opportunity to read it.
Absolutely, Your Honor.
And then as it relates to how you want to lay out your, you just make your argument. Is that what your question was?
Yeah, Your Honor, I think there's a couple different arguments that I need to respond to defense counsel to see.
You mean you want to respond to their motion or their response?
Yes.
Wait a minute
to their
here.
response.
This is a concern. Let's see here. Is that the one that has the wrong name on it? No. There's just 2 copies of the defense reply in here. I don't see the prosecutor's motion at all. Defense reply to prosecution's motion, defense reply to prosecution's motion. This one has a date stamp, this one doesn't. So where's the prosecutor's motion? I know, I believe I have it.
I submitted on October 10th. You should have it.
October 10th.
Still.
That's what I'm saying. April.
April 10th. Losing my mind.
You can have a seat, Mr. Davis. This has to be corrected and then we'll get this taken care of.
When you say you can have a seat, you mean them guys?
You can have a seat back there. This is the state of Michigan versus Jalen Shamar Davis. And then file number 26-00030. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
Assistant Public Defender Justice Rob on behalf of Mr. Jalen Shamar Davis, who is standing to my right.
Today was debate set to address a hearing on a motion filed by the prosecution, which was people's notice of intent to introduce other acts of domestic violence under MCL 768.27B and out of court hearsay statements under MCL 768.27B. The court is in receipt of both motion and brief filed by the people and the responsive brief filed by the defense. Counsel, you can make your argument.
Okay, Your Honor, I think, you know, we may be a little bit premature, make some conclusions, but I wanted to first start off by addressing defense counsel's allegation of Sixth Amendment confrontation clause violation.
Okay.
So first, I believe we have agreed to some extent that the complaining witness in this case does not have to appear automatically and for there to automatically be a confrontation clause violation. I believe based off of my reading of defense counsel's motion, she has conceded that point. So can we start there?
Absolutely.
Well, I think what really matters, right, is whether or not the complaining witness's statements via the 911 phone call, as well as the body worn camera footage, would be considered testimony. And so I think our argument from the defense's standpoint is that they are indeed testimonial due to there not being an ongoing emergency at the time that those statements were made. We refute that there is an ongoing emergency based on the information or statements made by the complaining witness herself. On the 911 phone call, she's very forthcoming about the fact that she initiated physical, forcible contact with Mr. Davis by smacking his phone out of his hand because he was essentially capturing her via a video telephone call. And she felt like that made her look like a bad person. She says this 3 times. She says it twice on the 911 phone call. She also says it during the interrogation by the police once they had physically arrived at her address. And those statements were captured via the body worn camera footage of the officers. So based on the fact that she herself is admitting to the fact that there was not an ongoing emergency, but rather a disagreement that she herself catalyzed, I do believe that those statements should be considered testimony.
If I may.
Yeah.
So I think, again, to address the first issue and not to go over the counsel's point, but the first issue we addressed was whether or not the state, the people had the ability to put on the case absent the complaining witness. So I believe we have both consent that that's not an issue, and the people could potentially put on the case absent the complaining witness coming to testify.
I mean, I think that that's clear
Okay,
because that's what 768.2017 allows.
right. So,
Provided that proper foundation, obviously, is met for the purposes of bringing in that hearsay under that rule of exception. And that, you know, it was made to an officer, that it was made in response to a domestic situation, that there's some reliability, all of that stuff has to be in place. If that's the case, then the precedent is that we can bring in that evidence absent the witness. Hey, why is the witness unavailable?
she just doesn't want to come.
Oh, she doesn't want to participate. Okay.
Yeah.
Okay, so now, as it relates to the confrontation clause, you were making arguments, so.
Well, again, to the confrontation clause, again, I don't think that, so to the 911 call, to the confrontation clause of the 911 call. So my position is that the complaining witness in this case was making a 911 call in order to convey an emergency, in order to have the police respond to that emergency. Yet she may have, I mean, I believe the case law was clear on this. She may have, you know, made statements about what happened, you know, that brought police officers to her home on that particular day. But I think the case law is clear that 911 calls are not inherently testimonial. So I would, so that would be my argument to the 911 call.
Do you want to respond as it relates to 911?
Just to clarify, Your Honor, that is not my understanding of the case law. In fact, my understanding of Michigan versus Bryant is that statements made to a 911 operator while the crime is occurring are non-testimonial, while statements made to an investigating officer after the crime had already occurred were testimonial. So I don't believe that.
Let her finish.
I'm sorry.
I don't believe that the case law is blanket restating that 911 phone calls are just per se non-testimonial.
Depends on the condition or the time frame of when that 911 phone call is made, because one of them is made more or less as an excited utterance, like, you know, urgency, whereas the other not so much, like reporting a late crime? Is that your position or your understanding?
Relatively, yes, Your Honor. I think the ongoing emergency part is the most important part of this. The case law also differentiates ongoing emergencies that affect the greater public versus the smaller forum of a couple's dispute. The case law does say that statements are testimonial if they relate to an incident that is actually a private dispute. Again, Michigan versus Bryan.
Did you want to respond, Mr.
Yes.
Smith?
So specifically about the 911 call. So the 911 call was made to dispatch. The dispatch, they dispatched to 911 dispatch, and then they dispatched officers to the complaining witness's address. When the police arrived at the complaining witness's address, they are still looking for the defendant because it's told that it was told to officers that the defendant had a gun. So when they arrived on location, they were responding to the fact that the defendant got into an argument with this complaining witness, that he ran out of the house with a gun. So that was their initial response once they got there. And then when they initially arrived, they did a protective sweep of her house to make sure the defendant was not still in there with the gun. So the officers questioned the complaining witness once they got there about the gun. They made some preliminary findings of whether or not he was going to be taken into custody based off of him having a gun. So the 911 calls were to report that event, and then the subsequent body worn camera is based off of the allegation the defendant pleading or in the area with a firearm. So I would argue that that's an ongoing emergency.
Any further?
Your Honor, I just would like to clarify. I think we've got two things happening. We've got 911 statements happening, and then we've got body worn camera.
That was clear in their brief.
Well,
Right.
just in terms of our argument, relative to the 911 call, okay, I think that the complaining witness, not just in her own statements where she's identifying herself as the aggressor in this circumstance, but she also demonstrates this through her behavior on that phone call. She's yelling quite consistently at Mr. Davis, asking him to leave. And so, you know, at that point when he does leave, I don't think that it's necessarily fair to, at that point, contest that we've got now a public ongoing emergency when literally that's what the complaining witness is asking for, is that he leaves. Michigan versus Bryan also states that statements are testimonial if they are made in circumstances where a perpetrator is disarmed, surrenders, is apprehended, or as in Davis, flees with little prospect of posing a threat to the public.
But you just said that at the time of the call, she was yelling for him to leave.
Yes, and also using very derogatory terms. She did not appear to be in fear or in danger during
Because
the
she's
call.
using derogatory calls on names while she's calling the police.
Yes, the operator is consistently insistent that she could discontinue her communication with him, but she continues to be aggressive throughout the entire call.
Okay, so this is allegedly the victim is at her home.
Correct.
She's calling 911 and she's excited, she's yelling.
Yes.
And she's actively yelling while on the 911 dispatch for the defendant to leave the home. So you don't think that's ongoing?
An emergency? No, Your Honor.
Actively yelling.
Why? I'm sorry. Why wouldn't that be an why? If it'd be different if she called and he had left the home, but he's actually in her home at the time she's calling and screaming.
Yes, and she got to this point, Your Honor, simply because he had engaged in a phone call with his mother and his.
He had allegedly engaged in a phone call with his mother and his aunt about what? Allegedly.
about the disagreement, whatever it was, and it made her feel like she was being highlighted. She says this expressly on the 911 phone call, that it made her feel like she was being highlighted as a bad person, and so she
called the police allegedly because she felt like she was being highlighted as a bad person, or did she feel threatened by him calling his mother and his sister?
I'm not from. So
I don't. You have an attorney. If you be your best interest to let her speak for you. Because I don't even know why you're not being from here. It's nothing to do with what she's arguing. You could be from a whole other continent for all we care. We're on this day in question.
Scared. So
You said what?
you said she's scared.
No, I said I'm asking your attorney a question about, we're trying to identify whether or not this is testimony or non-testimonial evidence. You know the difference?
Yes.
What's the difference?
So a non-testimony is pretty much so a testimony is pretty much somebody just telling their statement, right?
No, that's why you let the attorney do what she's supposed to be doing and don't interject, okay? If you want something for her to consider, you whisper it to her, but you don't blurt out on the record,
I understand.
because she's the
I mean,
one
everything I
who
said is
studied the
true, so
law, okay?
I understand.
So she's trying to create a defense for you.
I understand.
Don't disrupt her flow. It's not gonna help you, okay? You can continue.
Your Honor, not all disagreements are emergencies, and I do believe that I don't mean to reduce the complaining witness's statement by any means. I'm sure she felt how she felt. I am just simply highlighting that I don't believe, based on the circumstances of that 911 phone call and the statements that she made, that there was an ongoing emergency, refuting the notion that these statements are non-testimonial in nature.
So you don't believe that if someone is in a domestic relationship and they are in an argument that accelerates for whatever purpose, if they're asking or screaming for someone to leave for whatever reason, that person refuses to leave, and they call the police for assistance, that's not an emergency, because they were in the middle of a heated argument that could escalate. That's not an emergency.
It's certainly not an emergency to the public, Your Honor.
It's not an emergency unless what? Someone's hit first, or what do you believe triggers it now to become an emergency?
You know, in the case at hand where this incident or where these definitions stem from, there was a person, I do believe in Detroit, who was in the public and had shot a person. In that situation.
Are you talking about the Bryant case?
Yes, Your Honor.
Okay.
The victim in that case was made statements to the police as the police were actively trying to identify what was happening, what was going on, and they had active fear that that ongoing emergency would affect the larger public, not a simple group of people, not a smaller, should I say, group of people. In domestic situations,
so you believe that if it only affects a smaller group of people, is that your argument?
I'm just going based off of the case law, Your Honor. It does say that domestic violence cases often have a narrower zone of potential victims than cases involving threats to public safety.
So I think the defense counsel has did a good job making a little bit of my argument for me, but and that's no shade to the defense counsel. But so again, what is the larger threat to public safety that was posed in this case? Again, the complaining witness called police after the defendant refused to leave her home after they got into a domestic dispute. That's on the 911 call. That's clear. The complaining witness alleges that the defendant had a gun with him, and that the defendant was in the area of her house with a gun. So when police show up to this ongoing emergency based off their allegations of domestic assault, person with a gun in the area, police show up. Police, we don't know whether or not police would have confronted the defendant, whether or not they would have, based off there being a gun there, whether or not they would have had to use force in the larger community because his allegations of a gun. But when they got there, they had to do a protective sweep of the home to ensure that he was no longer in there with a gun. So to the extent that this wasn't an ongoing emergency, I believe it's an ongoing emergency from the time that she made the 911 call about the original domestic violence incident until the time that police arrived. They determined that that Mr. Davis was no longer in the home with the gun, and they did a protective sweep of the home and no longer, and that allegation that he was there with a gun no longer posed a threat to the complaining witnesses or to officers that were on scene. So at that point, I would say the ongoing emergency had ended. So we ask that any statements made between the time of the 911 call to the time that police officers concluded their protective sweep of the complaining witnesses apartment, we ask that that all be omitted as non-testimonial hearsay under the ongoing emergency exception.
Okay, any additional arguments? I think I've heard your arguments. I think you both are, I mean, we're going where I was going when it relates to the major issue really is the 911 calls, not so much body cam. Nonetheless, the case cited Michigan versus Bryant. I need an opportunity to read that. I recognize you cited it, but I didn't have an opportunity in that short time period to read it. And so I will be doing that prior to issuing my official ruling. However, I am going to be very candid. I disagree with your position on whether or not there was an ongoing emergency. If someone's calling 911 while someone unwanted subject that they're in a domestic violence situation, which we know adds an element there, is in their home and she's yelling, I don't care if it's expletives or not, and she's yelling that she wants this person out of her home, and then allegedly this person has a weapon, there's an ongoing emergency. I don't think that's disputed. That I would agree with the prosecution should extend from the time she's making these statements to the time that the police are there to do their protective sweep to ensure that he has left the premise and that there's no longer an ongoing emergency because he's not hiding outside her house or hiding in a bedroom. We don't know that if that's the allegation. I'm going to read the case law that you've cited. I will make the final determination. I am making it clear there, I think so much on this record where I align. And my inclination is that the prior acts are admissible, both under 27C, but also that there are no violations in this present case as laid out by the prosecution for a confrontation clause. If my reading of Michigan versus Bryant changes that, I'll address that at the next court date, but you'll get my official ruling on the date of the and time of trial, which I believe is got to be rescheduled, correct?
Please, Your Honor.
July 7th at 8 a.m. July 7th at 8 a.m. is the next available date. Was there something else?
Did you already address the prior bad acts? I did think
I think the prior Brett, I did address it for the most part. I believe that they're admissible. And so we'll address the 911 confrontation clause issue in more detail I guess on July 7th. As you can see, it's April and we're scheduling now into July, which is why the court takes the position the court takes about playing around with jury trial slots as it pushes things out unnecessarily. So that's just the next available date, and that could change. It could get bumped, because I don't know, sir, if you have the priority case for that date either. It could be an older case scheduled for that date, and they would have to go before yours, okay? So unfortunately, the case will continue until we can get it resolved. We'll do our best to gauge whether or not this is actually gonna run as a trial on the 7th, so that you don't waste time taking off work if this just needs to be reset. But it's difficult to do that when you have situations where people don't show up when they're supposed to show up for trial. Or other circumstances could come into play. So, yes, sir.
See, I got one question, because it's been almost 4 months since I've been on this tether, and I haven't made not one violation. Other than what I want, other than my charge, I feel like there's really no point for this tether.
You're making a motion to have the tether removed? Is that what you're making?
I'm
Motion?
just asking.
That's what I'm asking. You're making,
Yeah,
you can have the tether. I've not
I'm
had any
having
violations.
bruises in my leg.
You can have the tether removed,
Thank you. I appreciate it.
but the no contact order will continue. Any additional matters?
Nothing from the people.
Thank you.
By the end, the judge made her position crystal clear. A screaming 911 caller, an unwanted man inside the home, and allegations involving a gun absolutely sound like an ongoing emergency. The defense kept trying to shrink the situation into a private dispute, but the court wasn't buying it. And even when the defendant finally scored one small win, getting the tether removed, the no-contact order stayed firmly in place. So here's the question. Was the defense making valid constitutional arguments, or just trying to explain away obvious danger? Comment below, hit like, and subscribe for more real courtroom breakdowns.